What are the 5 big questions to ask when your foreign-born spouse has been in the United States for way too long? Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States out of our offices in St. Louis, San Diego, and Washington, D.C. In today's video, we're going to tackle that thorny question of what happens if my spouse has been inside the United States for way too long. There are 6 questions that we ask every single time we are presented with such a scenario, and I'm going to share them with you along with my thoughts on how it may impact the foreign national's ability to obtain lawful permanent residence, i.e. a green card, here in the United States. The first question is, how long has the spouse been here in the United States? Now, if they are marrying a U.S. citizen, if the petitioner is a U.S. citizen, it doesn't matter how long that they've been here. They could have overstayed by 6 months, 6 years, or 16 years. The fact of the matter is that if you marry a U.S. citizen and you've overstayed your visa and you've been here in the United States for a really long time, that overstay is forgiven if the green card application is approved. Now, if the petitioner is a green card holder, that is, they're not yet a U.S. citizen, that could affect the ability of the foreign national to adjust. That is, the spouses of green card holders are not forgiven in the same way that spouses of U.S. citizens are. So we're going to have to dig deep and get the exact details of how long they've been here. And then we're going to want to look at when can the green card holder get their citizenship. It might be better and safer to wait to file the I-130 until the petitioner is either a U.S. citizen or is about to become a U.S. citizen. You probably don't want to raise your hand and say that you're here if your petitioner's spouse is a green card holder, because you don't get those same protections. If a green card holder marries that foreign national who overstayed, they could be eligible for a waiver. Now, a waiver might cure the overstay if we can show that there be an extreme and exceptional hardship on the green card petitioner if the foreign national was not allowed to adjust status. But those kinds of cases are a lot more expensive, they take a lot more time, and there's a lot more work involved because you have to get the actual waiver approved, and it oftentimes involves the foreign national leaving the United States temporarily to go overseas and obtain a visa to come back to the United States. That is scary and thorny for a lot of foreign nationals, and a lot of times that makes them want to wait until the green card holder petitioner becomes that U.S. citizen. The second question that the attorneys at Hacking Immigration Law ask when presented with a scenario where the foreign national has lived outside the United States for a really long time is, do they have a valid entry? That is, were they inspected by a customs official when they came into the United States? The federal immigration law makes a huge distinction between people who were inspected and people who were uninspected. So that second question that we're always going to ask is, tell us about the inspection, tell us about the entries, show us the stamp in your passport that demonstrates that you were admitted legally into the United States. I often tell people when they come to see us and they show me their ages old visa stamp and the proof of their valid entry into the United States, that is the most valuable thing that you own. You might be the only person on earth who has that proof that you entered the United States legally. A lot of times CBP stamped you, but we can't find those records. So when you have that old passport, maybe it's expired, with the valid entry, you need to keep that in a very safe place. You also need to take a picture of the stamp right away so that if anything does happen to your passport, you at least have a digital copy, because that distinction between people that were inspected and those who were uninspected makes a huge difference in when you can apply and whether you should apply for a green card based on marriage. So that's the second question we're always going to ask is, tell us about the entry. Next up is our third question that we ask, and that is, when did the valid status expire? When did the valid status expire? So this is assuming that the person entered on a non-immigrant visa. Recall that there are many different kinds of non-immigrant visas. Some people are allowed into the United States on a B1, B2, which usually means they can only stay for 6 months. Others, like F1 and J1, are allowed in for the duration of their status. They're allowed to stay here as long as they maintain their status, keep going to school, and don't violate the terms of their status. So we're often going to want to drill down to find out, well, exactly how much time do you have out of status? It doesn't legally matter necessarily, but we like to have a very firm timeline of all the events in the person's immigration status. One reason for this is that a lot of times, if they're getting married at around the time their legal status ended, that sometimes can be a fraud indicator for USCIS. That is, they get suspicious if a marriage occurs right before someone's valid status expires. Not always the case, but that can certainly be a red flag, and that's something that we're going to want to talk through with the clients to make sure that we're all on the same page as to why they got married, that they aren't getting married for an immigration benefit, and that the plan was because they were in love and they wanted to stay together, not to confer an immigration benefit or to quote unquote help somebody out. The next thing we're going to want to know, question number 4, is did the foreign national work in the United States? Now, this is a huge question. Obviously, if someone has been in the United States for years and years, they probably had to support themselves. Most likely, they don't have a rich mom or dad back in the home country sending them money every year or every month to make ends meet. More likely, the foreign nationals here in the United States and working and sending money overseas. So I'm always a little bit laughing when I ask my clients or potential clients about, well, you've been here in the United States for 12 years. How have you supported yourself? Have you been working? Oh, no, Mr. Jim, we haven't been working. And then I sort of pause for a second, wait, and then they tell me the truth that they have been working. And the reason that unauthorized work is so important is, again, if you're married to a U.S. citizen, that's forgiven as long as you tell the truth about it, but you can't lie about it. And the other main issue with working is, did you demonstrate that you had the ability to work in the United States? What we're concerned with here is, did you lie about your immigration status in order to be able to work in the United States? That's the real question. Taxes may be important. We're going to talk about that in a minute. But the real shooting match here is, did you lie or misrepresent your immigration status in order to be able to work? A lot of times, USCIS will go out and request the records from the employer to see if you marked on the I-9 form, which is the form that you complete when you start employment. Did you mark that box as a U.S. citizen? Because if you have a false claim to citizenship, that can sink your green card case. That's a deportable offense, and that can keep you from ever getting any immigration benefit whatsoever. So whenever I hear about a long-time visa overstay, I always go to a false claim to U.S. citizenship first. I always want to know, how have you been here for so long, and how have you been supporting yourself, and what did you tell your employer at the time of hiring? Now, some employers don't care and they just let you work. Other employers do go through the I-9 process, and we've seen it time and time again where USCIS asks for the records of the employer, and they want to make sure that you didn't make a false claim to citizenship or use the identity documents of somebody else. That's not as serious, but it is a serious issue that we're going to need to overcome. The 5th issue follows right along that, and that is taxes. They want to make sure that you have been paying taxes, that if you've been working, they're going to want to get the records of your taxes. They're going to want to know whether or not, you misrepresented yourself on your taxes. They want to know, have you been following the law? They want to know, are you going to be a good resident in the United States before they get to that? So we always ask about taxes, mostly because that's going to allow us to sort of flesh out the issue of employment that we discussed in issue number 4. The 6th and final issue, which is probably the most important issue, and that is, does this marriage seem legit in light of the timeline? In other words, obviously, every single time we file a marriage-based green card case, the burden is on us to demonstrate that the marriage is legitimate. But when someone has been out of status in the United States for a really long time, that is one of the big fraud indicators for USCIS. When somebody has a big immigration problem by having worked in the United States and by having overstayed their visa or been in the United States for a really long time without permission, marrying a U.S. citizen cleans a lot of that stuff up. So this is one of the reasons why USCIS guards these green cards very carefully, why they really inquire deeply into the applications. And I would say that if the foreign national has been in the United States for a long time without permission, that they're going to be held to a higher burden. So it's higher than what it normally would be for a regular marriage. This is a situation where if you've been out of status, if you're in removal, or if you've overstayed and then you get married, they're going to hold your case to a higher standard. So they're going to want to know, is this marriage real? Do I believe this? And they're really going to look at the timeline, because if someone's been out of status for 16 years and then all of a sudden they meet someone at the gas station, get married 2 months later, and then apply for a green card, that's a little bit differently than if someone's been here for 16 years but has been in a relationship with someone for 4 years or 5 years and then got married and then went ahead and applied for a green card. That's a very different thing. So you have to take sort of a totality of the circumstances. How does everything look all together? And given the fact that the foreign national is out of status, that marrying a U.S. citizen would clear up a lot of their immigration problems, do we believe, in light of all the facts, that this is a real marriage that wasn't done just for the purposes of obtaining a green card? So these are the 6 questions that we look at. We hope you found it helpful. If you have any questions about the marriage-based green card process, give us a call at 314-961-8200. You can email us at info@hackinglawpractice.com. Be sure to join us in our Facebook group, which is called Immigrant Home. We have thousands and thousands of members in there. We also have our YouTube channel that you should think about subscribing to. That way you'll get notified whenever we go live, which is usually 3 or 4 days a week, where I answer all of your immigration-related questions for up to an hour, a few times a week. Thanks a lot, and have a great day.